Welcome everyone to Current in 30, the 30-minute webinar series brought to you by the Current Consulting Group. We are thrilled to have you with us. To briefly introduce this series, each session is designed to keep you informed, efficient, and ahead of the curve. On the second and fourth Mondays of each month throughout 2026, we'll break down key things you need to know about workplace drug screening, from emerging trends and regulatory updates to best practices and practical implementation tips. If you missed our previous sessions, please visit our website, currentconsultinggroup.com, or our YouTube channel at Current Consulting Group to view those sessions. And thank you for joining us today. I'm Greta Walsh of the Current Consulting Group, and today's presentation is titled, Addressing Marijuana in Your Drug Testing Policy, Complacency is Not an Option. This presentation qualifies for half of a professional development credit from SHRM and HRCI for those who attend today's presentation in its entirety. Today's presentation welcomes the founder and president of the Current Consulting Group, Bill Current. Among Bill's many accomplishments, he founded the Current Consulting Group in 1998. He is a former VP of Consulting at Employee Information Services. He is a former executive director of the American Council for Drug Education. He is also the former director of the Institute for a Drug-Free Workplace. He has authored 11 books on substance abuse prevention and drug testing, and he is currently a member of the board of directors at Endesa and board of trustees at the Endesa Foundation. And now it's my pleasure to turn it over to our presenter, Bill Current from the Current Consulting Group.
Thank you very much, Greta, and welcome everyone to today's webinar presentation. As Greta was introducing me and mentioned that I have been the director of the Institute for a Drug-Free Workplace, it reminded me of something that happened a couple of weeks ago. I was rummaging through some boxes in the garage and found a copy of the first book I ever wrote called A Guide to State Drug Testing Laws and Legislation. I actually co-wrote it with some other folks there at the Institute. And I just thought it was so interesting because that was in 1991. There were about 16 states back then that had a drug testing law. And of course now every state either has a law or some type of regulation, or their workers' comp or unemployment comp includes drug testing, or some of their marijuana laws mention drug testing. And there's tons of case law all these years later. And so today's presentation is going to talk about some of this legislative activity and how it affects drug-free workplace programs and drug testing in particular. And as we go through it, think about questions that you would like to ask. If there's something, just put it in the chat function or the Q&A function, and we'll get you an answer one way or the other. But we're going to go through basically sort of this agenda here. But if there's something related to this, or it's not exactly on the agenda, but it's something you'd like to answer, or you'd like to ask as a question and get an answer to, feel free to do that. Put that in the section and we'll get to it. I'm going to start out with a little bit of information that sort of sets the table, if you will, for the content of today's presentation. And I'm going to start with sort of key questions to ask. Now, the 2026 legislative season is going to be monumental, I think. It's going to be very consequential among employers who are conducting drug testing or considering testing, or specifically testing or not testing for marijuana. Over 500 bills are being considered at the state level. And you see in that third bullet, I said state lawmakers are redefining the balance. And what I mean by that is the balance between employee rights to use marijuana and to have that privacy guarantee, and employers' obligation to provide a safe workplace. And so we're seeing in today's legislative activity at the state level expanded protections for medical marijuana users in particular, but also explicit employer immunity provisions. I'm going to share examples of all of these coming up in future slides here in a minute, and also anti-discrimination mandates. These are the key issues that we're seeing in the marijuana laws. Now, if you think back, several years to when the first medical marijuana laws were passed at the state level, they were really sort of very kind of weak laws in the sense that they didn't really take on employers directly. The objective, I think, of the legalization movement, 15 years ago or so, was to get laws on the books that made it legal to use marijuana for medicinal purposes. But a lot has changed over the last 15, 20 years, and you're seeing a lot more activity toward squeezing employers in particular when it comes to legal marijuana use by their employees or by job applicants. And that's why you're seeing expanded protection language for medical marijuana users and anti-discrimination language where it prevents employers from, taking adverse employment action when somebody tests positive for marijuana, or refusing to hire a job applicant who fails a pre-employment test because they tested positive for marijuana. And it's creating a kind of a trend. And the trend is seen in this survey. Now, every year, the Current Consulting Group conducts a survey of the drug testing industry, which is in the first half of the year. We present those results at the NDASA conference. We'll do that again this year in April in Anaheim, California. And then we also do an employer survey in the second half of the year, and we present those results at the SAPA conference, which we'll do again this year in Minneapolis. In last year's employer survey, the 2025 survey of employers, we asked the question, what is your company's position on testing for marijuana? You can see at the very top, 73% said they plan to continue testing for marijuana. When compared to the 2024 results, that 73% was down from 77%. So that's a significant drop in the percentage. Now, we're not interviewing the same people from year to year or getting an exact scientific read between one year and the next, but it does show a trend there. We'll see in this year's survey, in the second half of the year, when we survey employers again, whether or not that's a trend that's continuing. Is it going to drop from 73% to something else, or will it go up again? Will it stay the same? We'll see. But this slide in particular, these results from the 2025 employer survey perhaps are showing us that there's a trend toward employers being unsure about their right to test for marijuana or about their resolve to continue testing for marijuana. So that leads us into the discussion about legislation. Now, at the state level, lawmakers introduce legislation, and it's there's a lot of marijuana legislation, and we bring it up in a drug-free workplace webinar like this because a lot of that legislation affects the workplace. It affects drug testing. It affects employers' ability to take some type of action based on a positive result for marijuana. So we're seeing a lot of that, okay? The question that you have to ask if you're an employer, and if you're a provider, a drug testing provider working with employers, these are questions that are critical to the success of your program and the compliance of your program with applicable state laws. Does your policy reflect current state drug testing statutes and marijuana laws? So important, right? If you're a multi-state employer, you have to comply with all the different laws that apply to your company. If you're in 25 states, you may have 25 different laws that you have to comply, or state laws that you have to comply with. In fact, more than 25, right? Because some states have multiple laws that affect drug-free workplace programs and drug testing in particular. And many states with marijuana laws, let's call them legal marijuana laws, will include language that affects the workplace directly, okay? Now, the second bullet, have any applicable states enacted new employee protections, notice requirements, or testing restrictions? You need to monitor these on an ongoing basis. And we do that here at Current Consulting Group. If you need help, let us know. But that's something that as an employer, if you're going to continue to conduct drug testing, and in particular, testing for marijuana, you need to stay up to date on any kind of legislative developments, laws that, and I'm going to share some examples, but laws that get enacted and what effect they would have on your workplace program if you're in that state, okay? As I said before, if you're a multi-state employer, you're probably going to have multiple addendums to your policy to make sure that in each state you're complying with the law that applies to you. Let me give you an example. Let's say that you're in California, which has some very restrictive drug testing language, mostly case law in that state, but in another state it might be an actual statute. or it could be a regulation, etc. But if you're in multiple states and you're one of those states is a state like California or New York or Massachusetts, which are very restrictive, not really employer friendly or drug testing friendly states, then you don't want to base your entire nationwide program on that one state that's the most restrictive. So you're going to have an addendum for the California operations of your company that maybe is, it aligns with and complies with the law in California, but doesn't restrict your drug testing program in Texas or Florida, which are more employer-friendly, drug testing-friendly states. So that's what I'm referring to when I talk about having multiple addendums if you're a multi-state employer. Let me give you an example here. In Minnesota last year in 2025, they updated their marijuana law and added some very strict written notice requirements, okay? Second bullet there, employers generally cannot discriminate based on, this is very interesting, based on an individual's enrollment in a medical marijuana program in the state or cannabis positive test results unless the use or the impairment occurred at work. That's very interesting language, right? So if somebody shows up to work under the influence of marijuana and they're trying to perform their job while impaired by marijuana, that could possibly lead to the employer taking action on a positive drug test result. I'm going to talk about how you get to that drug test result at the end of my presentation today. Now, in Minnesota, they also implemented some notice obligations where the employers are required to give employees advance notification of certain testing programs that they're going to implement, especially as it applies to marijuana. Now, in Florida, where I live, there are a couple of bills active right now, and both bills would grant employers immunity from civil liability if action is taken against an employee or applicant when, here are the conditions, cannabis use or possession occurs at the workplace, the employee is impaired while performing job duties or responsibilities, or the individual tests positive under a compliant drug testing program per Florida Statute 1112.0455. Now, in Florida, we have a workers' comp premium discount law. It's voluntary, so we call it a voluntary law. But if you are participating in that program, you qualify for a 5% workers' comp premium discount, but you must comply with the drug testing requirements of that law. Those would supersede some other restrictions that may apply generally to employers having marijuana drug testing programs, okay? So the point here is that you want to make sure in Florida, and this is different than many other states, that you're aware of these laws because they're really, if passed and enacted, they would reinforce your protections as an employer. They would strengthen your ability to take action, as those three bullets point out, when the use occurs at the workplace or the individual's impaired while trying to perform job duties, or they test positive in compliance with a drug testing program sponsored by the state. Now in Georgia, Georgia and Florida are very similar. Georgia was the first, Florida was the second, as my recollection tells me, to pass these workers' comp premium discount laws, these voluntary drug testing laws. It's some order like that, Georgia, Florida. So in Georgia, there's active legislation now for recreational legalization of marijuana, but that bill as it exists right now does not include any employer provisions. This is unfortunate because it's going to create some ambiguity. It's going to create some confusion if passed the way it is. Do employers still have the right to test for marijuana if the individual is using marijuana on a recreational basis? And other things that come up with that. Now, the second bill right below that renames low THC oil as medical cannabis, and that expands the qualifying conditions. And so if an individual, an employee or job applicant is a registered medical marijuana user and they're using THC oil, if this law is passed, it would treat THC oil as medical cannabis. The other bill, though, has to do with legalizing marijuana use for recreational use. So the takeaway here, as you see in the final bullet, recreational legalization proposals without workplace language can create ambiguity, and employers should clarify impairment standards in their policy. Indiana and Illinois, two really kind of interesting situations here. In Indiana, this bill, there's a Senate Bill 0286, legalizes medical and recreational cannabis. Okay, it explicitly protects employer zero tolerance policies. Remember, in the previous slide, in Georgia, there were no employer provisions, at least not yet. But in Indiana, it would explicitly protect employers' zero tolerance policies and clarifies that prohibiting work while under the influence is not unlawful discrimination. So you see a lot of anti-discrimination language either originally in a marijuana law or being added to an existing law. But in Indiana, if passed as written, it would clarify that prohibiting work while under the influence is not unlawful discrimination. Now go down to the bottom, Illinois. This is interesting because this one has to do with legalizing psilocybin. So we're talking about other types of drugs, psychedelics and other substances that, not necessarily marijuana, of course, but all sort of part of this marijuana legalization movement from, over the last 20, 30 years. In Illinois, this bill would legalize psilocybin, but it does not prohibit an employer's ability to restrict the use of controlled substances by employees. Now, to what extent? That's always the key issue, right? But we're starting to see more of these other drugs besides marijuana, other types of legalization bills being introduced. In this case, psilocybin, but it could be other drugs. As many of you probably know, in Oregon several years ago, they moved to legalize all illicit drugs, including cocaine, heroin, fentanyl, etc. And it backfired so dramatically that they had to undo the law because the drug problem had become so much worse as a result of that. Now, let's talk about drug testing, and we're gonna have some more state law examples coming up to help us with that. So you want to confirm that your policy clearly addresses these issues that we've been talking about. It's the blueprint to your drug-free workplace program. It's the thing that guides your employees and your supervisors toward maintaining a drug-free workplace, okay? It makes it possible for you as an employer to accomplish your drug testing objectives, whatever they may be. You're going to articulate that in your policy at the very beginning of your policy in some type of a purpose statement. But what comes after that will, and of course, having your employees understanding what is required of them and when testing may occur, etc. That's all key to accomplishing the objectives of the program, but it's articulated at the beginning of your policy in your purpose statement. Now, the third bullet down, unfortunately, too many employers' policies are either outdated or incomplete. Since they wrote it, there could be, changes to drug testing laws themselves. Of course, there's marijuana legislation that's popping up every year and existing marijuana laws that are being changed on a regular basis. Maybe you've adopted a new testing technology. You've gone from urine testing to oral fluid testing. Well, all of those things necessitate an update to your policy. So in our employer survey, we asked the question, when was the last time you updated your policy? 39% said in the last year, 27% said it had been between 1 and 3 years, 15% said it had been over 3 years, and 12% didn't know. In fact, 6% said they've never updated their policy. So we run into this all the time because that's our main business at the Current Consulting Group, is writing policies. That's why we maintain our state law database, Current Compliance, because it helps us stay up to date on the ever evolving legal landscape of drug testing. So when we write policies, we're writing compliant policies. And any employer that has a drug testing program should update their policy on a regular basis. Now, we also ask the question, why did you last update your drug testing policy? And you can see this goes right with the topic of today's webinar. 33% said in response to recent state law changes, and 26% said to comply with legal marijuana laws. So we're really talking about the vast majority of employers who are updating their policy whenever they do update it because laws are changing. In particular, marijuana laws are having an effect on their workplace. Now, in all 50 states, employers have the right to prohibit employees from bringing marijuana into the workplace, using marijuana while on the job, or being impaired or under the influence of marijuana while working. All 50 states, no matter how liberal your state is when it comes to marijuana, no matter how restrictive your marijuana law is when it comes to drug testing or employers' rights to take adverse employment action based on a positive result, all of that aside, in all states, you can prohibit employees from bringing marijuana into the workplace, using it while on the job, or being impaired by it while working. So, why test for marijuana? Lots of reasons. I just wrote a book called What Every Employer Should Know About Marijuana. And I finally just had to cut off that chapter because there was so much data out there on the levels of marijuana use. But let me pull out just one part of it, which is employees using marijuana on the way to work or while on the job. So there was a survey a few years ago of 500 employees who admitted to being regular marijuana users. 31% confessed that they used marijuana during their commute to work, and 77% said they used marijuana at home before leaving for work. In another survey of 1,000 admitted illicit drug users, and it didn't specify marijuana, but of course that's the vast majority of drug use in the United States, illicit drug use, I should say. 28.2% admitted to getting high on the way to work. And in our 2024 drug testing industry survey, we asked drug testing providers if employers' decision to discontinue testing for marijuana encourages their employees to consume marijuana before work. Excuse me. And 59% said yes, they believe the decision to discontinue testing for marijuana does encourage individuals to consume marijuana before they start their shift in the morning or the afternoon, etc. Now, we also wanted to talk about employees' use of marijuana while on the job, right? So in another survey altogether, 1 in 5 individuals said that they have used marijuana recreationally, not for medicinal purposes, but recreationally in the workplace during work hours. And in that survey of 500 marijuana users that I cited on the previous slide, 48% admitted to using pot at work, either during breaks or while actively working. Now, in the survey of 1,000 admitted illicit drug users, this was interesting, I thought. Nearly 23% said they get high while on their lunch break. 11.5% said they get high in the afternoon while at work, maybe while they're taking their afternoon break. 10.5% said they get high in the morning while at work, so they get to work and then they get high. And then just over 5% admitted to getting high on their way home. So after a stressful day at work, while they're driving home, they're lighting up and getting high on the way home from work. Now, we know that individuals who use marijuana just before they start their work schedule are probably impaired at some point during the day. There's I think it's on the next slide, let me see. Yeah, there was an analysis of 80 scientific studies from around the world. This was back from 2021. That concluded from all of these different studies that have been done in all different parts of the world that impairment from cannabis use is somewhere between 3 and 10 hours. I'll come back to this slide in a second. But on this slide, just wanted to talk about drug testing methods, right? So urine drug testing identifies or detects the metabolite of cannabis. And that takes about 6 to 7 hours to become detectable in someone's urine from the time somebody uses marijuana. Oral fluid testing is different because it detects the parent drug, parent THC, the psychoactive form of the drug. And that becomes detectable in an oral fluid sample within about 10 to 15 minutes after usage. So if somebody goes out to their car during their lunch break and smokes a couple of joints and they reek of marijuana, they're acting in such a way that triggers a reasonable suspicion drug test, and you collect a urine sample, if that's the only time they've been using marijuana for the last 24, 36 hours, then they're probably not going to test positive in that urine test. But if you conduct an oral fluid test, which is going to detect the parent drug, then, like I said, within 10 to 15 minutes of usage, that drug will become detectable in an oral fluid sample. And that may be what you're looking for. A positive, rapid oral fluid test result may indicate the person is actually impaired on the job. We're not saying the drug test proves impairment, but if the behavior that triggered the reasonable suspicion test in the first place comes with a positive drug test result because you did an oral fluid test, it may be enough combined evidence to be able to take adverse employment action if that's what you're looking for. Now, you're going to get the recording of this, so I'm not going to go into all of the information on here, but this study out of the University of Sydney was really fascinating in terms of the things that it took into account when trying to determine if, you know, how long impairment lasts. And part of it had to do with, part of it had to do with performing complex tasks like driving, where impairment may be more, may last longer and be a more complex issue than somebody sitting at a desk answering the phone. Now, in the Quest Drug Testing Index, which is a report that comes out annually, in 2023, they reported that post-accident positivity for marijuana reached a 25-year high. So in last year's report from the Drug Testing Index, it was just a percentage point or two below that. So it's really sort of maintaining that peak level from the 2023 report, that post-accident positivity for marijuana remains very, very high and very, very dangerous for employers. Now, let's talk about your policy. So I would say that under the circumstances, because of the legalization of marijuana and its widespread use, and the fact that many people admit to using marijuana on their way to work or while on the job, that drug testing has never been more important. It has proven to be a very powerful deterrent to drug use by employees and an effective way of identifying people who need help. But your policy is the key. A well-written drug testing policy that is in compliance with all the applicable state laws and regulations is going to be critical to your success in achieving your drug-free workplace objectives. So there's language on this slide that I think is very important, and I'm just going to read excerpts from it, right? The company respects the rights and privacy of all of its employees and will comply with all applicable state marijuana laws. Employees are prohibited, as I talked about before, from bringing marijuana into the workplace, using marijuana while on the job, which includes during breaks, and being at work while under the influence of marijuana. And job applicants and employees will be tested for marijuana in accordance with each applicable state law, meaning as a company, you state in your policy, we're going to comply with the laws that apply to us, but know at the same time that we will not tolerate marijuana use on the job or being impaired by marijuana while performing your work duties. Drug testing providers who are listening to this webinar should know the state laws that apply to their clients, their customers, and be able to demonstrate the return on investment value of continuing to test for marijuana. Because your job as a drug testing provider is not to simply sell a drug test, but it's to consult, it's to advise, it's to help employers make the right choices to help them achieve their drug-free workplace objectives. And that may mean using an alternative drug testing method, like oral fluid testing, if that's important to them. There is definitely a focus on impairment. Massachusetts, New Jersey, these are two examples of states that have active bills right now that include some type of impairment language or impairment requirement, evidence of impairment before an employer can take adverse employment action. And I will say this about impairment. There is technology out there now that may or may not detect drug use, but it accurately identifies impairment, okay? And there's lots of different methods that are out there. As you can see in that final bullet, there's computer-based programs, tablet-based programs. Some of them are kind of game-like. Some of them are based on the drug recognition expert program that has existed for many years in law enforcement, but it's out there now to work in conjunction with a drug test, not separate from a drug test, okay? And oral fluid testing, which the Department of Transportation a few years ago issued final regulations for lab-based oral fluid testing as an option for employers covered under the DOT regulations. We're still waiting for a couple of labs to be certified to conduct oral fluid testing, but that gives employers an option in how they're going to test for marijuana, with that tighter window of detection of about 24 hours for THC, and the fact that it can identify very recent use within minutes after usage. This may be the drug testing method you want for your reasonable suspicion or post-accident drug testing program. And a rapid oral fluid test may actually be ideal for pre-employment testing if you're in a very demanding hiring market where it's hard to find people, but you still want to conduct drug testing and you want to conduct drug testing for marijuana. So in conclusion, make your policy as solid and unassailable as possible. It's your first line of defense, as I wrote there. It articulates your drug testing objectives. It aligns with all applicable laws and regulations. And remember that you as employers can still hold employees accountable for bringing marijuana into the workplace, using marijuana while on the job, and being impaired by marijuana when working. But make sure you review the laws that apply to you. And if you need help, let us know. But make sure you review those laws and that your policy includes language that puts you in compliance with those laws, no matter what they may say in terms of anti-discrimination language, etc., so that you may go forward with confidence knowing that your program is designed for success. So that concludes my part of it, of today's presentation. And I'll now turn it back over to Greta.
Hey, Bill. We're reaching that 30-minute mark, so let's go ahead and wrap things up. Thank you to everyone today for joining us for this edition of Current and 30. We hope these insights help you stay informed and confident in your workplace drug screening decisions. As a reminder, this presentation was recorded and you will receive instructions in a few days informing you how to access the recording via email. Additionally, this presentation qualified for half of a professional development credit from SHRM and HRCI. For those who attended today's presentation in its entirety, if you have met that requirement, you will be emailed the activity IDs. Remember, we'll be back every second and fourth Monday of 2026 with things you need to know to stay current in this industry. Be sure to follow the Current Consulting Group and check your inbox for upcoming session details. Until next time, stay current and have a great day.